One of the things that's often forgotten about with the harassment or hostile work environment claim in California is that the conduct still has to actually be based on a protected status, such as your race, your gender, your disability, just to name a few of the protected statuses. Another thing that has to be considered when evaluating a California harassment or hostile work environment claim is how egregious was the conduct. The conduct generally still has to be severe, pervasive, or has to unreasonably interfere with the plaintiff's work performance. So if the conduct was minor and only happened one time, well, that might not be enough to meet the severe or the pervasive standard. On the other hand, if the conduct was repeatedly carried out over a period of time, well, that might be enough to meet the pervasive standard. And if it was really egregious conduct that happened one time, well, that might be enough to meet the severe standard. Another thing that has to be considered is whether there was a notice requirement based on who did the harassment. If the harassment was carried out by a coworker, well, the plaintiff may have to prove that the company either was put on actual notice or should have known about the harassment and failed to remedy it. On the other hand, if the harassing conduct was carried out by a supervisor, there may not be a notice requirement. So these claims can be tricky. And if you think you have a harassment or hostile work environment claim, you should definitely speak with an employment attorney. And if you happen to be in California, we'd be happy to speak with you.